as meaning that even if you've completed your job, you've installed material like a tile floor in someone's bathroom, if you failed to give that 3-day notice of cancellation, a consumer can send you a notice of cancellation, cancel the contract, demand their money back, and you have no right of set off as a supplier, meaning you have to give them the money back.
So there came your headline, your title, Seller Beware.
Seller Beware,
That's
exactly.
Now I'm getting it, yeah.
Now you see.
Seller Beware.
Right.
You do all the work, you pay all the material, but you leave out a key.
Some mandatory language. If you don't have that
somebody
mandatory
knows about
language,
well, you can't hardly take his tile floor back. So.
Right, and the way the law has been interpreted, because this is a consumer remedy type law, it's interpreted in such a way that too bad for the supplier.
Yeah.
They should know about it, and there's just no right to get your money back for what you put into that floor.
You raised probably a perfect example, because I mean we do this show Law Talk on a monthly basis, and last month I had Kathy Fortney on, and we were talking about foreclosures, and her point was an obvious one. We in Medina County, and I suppose all over, a lot of folks out of work.
Right.
People who worked in the manufacturing areas, their plants closed, and many of them are skilled people who can do home remodeling and whatnot. There could be a real danger here, and I'm glad you brought that up. I mean, not to say that a guy can't do that, just either confer with a lawyer or do some research, but make sure when you negotiate your contract, so to speak, with your prospective customer, you do it right.
Well, and that was my concern, because I know, and I've lived here all my life.
Sure.
I've grown up with a lot of these people. I know a lot of guys in the trades.
Yeah.
And I know they're not these big corporations who have money to draw on.
Yeah.
They're dependent on getting that final draw from a contract.
Angie's
and I've
list
seen it go
always
bad.
Brings forth a lot of names of individuals you can call, and people who would be more than willing to do this for people, and it doesn't necessarily have to be huge entities. But let's just talk about the consumer for a minute. I mean, it's really, we can go back to the guy that's installing, but from his perspective, so we now know a consumer, he entered into some type of a contract with somebody to remodel his bathroom. I mean, that's a perfect example. I guess then one of the big effects about the law that we're discussing today is that absent being advised of, did you say a 3-day?
A 3-day right to cancel.
So what does that mean,
Well,
Maryann? I mean, from the minute I sign it, I have 3 days to back out of it?
Right. You're given, again, the Home Solicitation Sales Act sets forth very specific requirements that your contract must be in writing, that it must have specific language advising the consumer of the right to cancel, and also there's a separate document called a notice of cancellation, and you have to give your customer 2 copies of those so that they have it, and if they choose to exercise their right to cancel,
so when we're sitting down at my kitchen table and I'm
you better get those 2 copies.
I'm negotiating with you about remodeling my you in this packet of paper you're going to give me, I gotta see
right those. And I also have to orally inform you of your right to cancel.
And if you goofed and you didn't, then you're saying you can come in, do the most beautiful job in the world on retiling my bathroom and whatever, and right at the end I could look at it and say, I don't want it.
It's almost like it's been referred to as a strict liability type of statute in case law, and as much as many lawyers and many courts bemoan having to apply this law to suppliers who might not really have done that much wrong.
Made an honest mistake, I guess. Just was unaware of the law.
Having as much as none of us are happy with that type of outcome in many circumstances, the reason it's there is because sadly too often you see folks who really are taken advantage of.
I see.
And I think we can agree being lawyers, sometimes, because our language is imperfect, sometimes you have to, in order to bring relief to innocent victims,
No,
everyone gets caught up in
that's why we have a state legislature
a bad
for it.
situation, right?
The constituents were telling our lawmakers, this is what we need, and it is the law. So and the purpose of why CC CLEP exists is to educate the public, both the consumer and the
You're right.
the purveyor here.
And as much as this is a troubling law for suppliers, I think what our legislature sees is that I think they're assuming most people who are going to be small business owners, there's a certain amount of responsibility to educate yourself and meet with professionals and find out what you need to do to comply with the law.
Yeah, and
I think they put that, it's easier to put that burden on the few folks who are going to undertake this kind of responsibility.
Fully understand that.
In order to protect consumers.
So the small business owner, Maryann, which, sometimes we overlook the small business owner, but a lawyer once told me that if it wasn't for the small business, capitalism would never exist. In other words, all of what goes on in the world is not General Motors.
I would agree with that.
In a little town like Brunswick, Ohio, or Medina, Ohio, we have a lot of small businesses.
Absolutely.
Well,
our business
both yours and mine.
Small business.
Small businesses.
Absolutely.
So as small business owners, of course, we're, well, I don't know, would fall on us as attorneys per se, but as small business owners, you've told us one thing that we ought to know about the law, and that is when you're signing up your customer, you better make it abundantly clear he has the 3-day right to get out of this project or get out of this contract. I guess that's sort of you might remember this. I sometimes have these little visions of law school come back and something called a unilateral contract, meaning that you get paid when you finish it, but if you don't finish it, you don't get paid. But there's also part of the common law that said that if you in good faith entered into this, you have a relief. But I think what we have here now is a statute that's actually overriding the common law.
It's going to supersede all of the, correct.
So your common law arguments aren't going to get you around this
thing.
No,
the case law that has interpreted this statute, again, it goes back to this is a consumer remedy. So it by law, it has to be construed in favor of helping the consumer.
Sure. Yeah. Well, when unilateral contracts, bilateral contracts,
really
for the benefit of our viewers, who are non-lawyers, of course, for the most part, contracts is a real big part of law school. I mean, every lawyer has to write some questions on the Ohio bar exam about contracts, most of which I'd like to forget about now. But point being is when you come along with a statute that will supersede contract law that goes clear back to, as I remember, cows and going back to England and I don't know, some of them in the 1500s and whatnot.
Sure.
I guess we are talking about a significant topic here. I guess one of the things that I found in I think it was in your article, it says, maybe you can clarify this for us. It states that the law, I took it right, I think, from your article. It states that a consumer is entitled to what they call treble damages if the supplier commits an unfair or deceptive act or practice. What are treble damages?
3 times any damages found. So, for example, there was a recent case where a gentleman entered into a deal with a car dealership because, again, Ohio consumer laws covers car dealership and car transactions. He, through some negotiations, they told him they would loan him or sell him the car for a certain monthly payment. He traded in his vehicle. He put $1,500 down payment down, and when he came back to get the car, they said, well, the financing, we couldn't get it at the price we told you.